Hello, I'm Joseph Lanza, and welcome to the Bethan Law Firm video educational series. Today we're going to be talking about how to get a lawsuit dismissed early, and there are two mechanisms for doing this in Texas. The first is called Rule 91A under the Texas Rules of Civil Procedure. The second is a statute known as the Texas Citizens Participation Act. Dylan, why don't you give us a quick overview of Rule 91A?
Rule 91A is a procedural mechanism that you would use in order to get an early dismissal of a lawsuit that was brought against you where the claims have no basis in law or in fact. In order to properly bring the Rule 91A motion for dismissal, you need to bring it within 60 days of receiving service of the suit.
Okay. And Dylan, in bringing the motion, what do you have to show or allege in that motion?
You need to show specific facts as why those claims have no basis in law, fact, or in both.
Okay. And if you are on the defense side of that, or if you're on the opposite side of that motion, what do you have to show in order to defeat that motion?
In order to survive a Rule 91A motion for dismissal, the party that originally brought the claim would need to show that they allege specific facts in there sufficient to show that they brought a plausible claim on its face.
Dylan, can you give me an example of when a Rule 91A dismissal motion might be appropriate?
A Rule 91A motion for dismissal might be appropriate under circumstances where, let's say a contractor had a job and one of their employees was operating heavy machinery, and it turned out that employee was operating it while they were intoxicated. And so obviously the contractor terminated that employee. If the employee comes back and sues the contractor for wrongful termination, under those circumstances, a Rule 91A motion for dismissal would probably be appropriate.
Thank you, Dylan. And that brings us to our next way to obtain an early dismissal, and that's through the Texas Citizens Participation Act. Dylan, can you tell us what the Tcpa is?
The Tcpa is an anti-SLAPP statute, and SLAPP stands for Strategic Lawsuit Against Public Participation. And those type of situations arise where a lawsuit is brought against someone with the primary motivation of silencing them. So the Texas legislature designed this statute, the TCPA, in order to allow the public to freely speak and participate in government to the fullest extent allowed at law.
Now, this act has had some unexpected consequences in the commercial litigation arena based on how broadly it's written. It's been applied to trade secrets misappropriation cases, non-competition agreement enforcement cases, non-disparagement agreement enforcement cases, fraud, and even DTPA cases. Fortunately for those of us who do commercial litigation, the legislature recently amended the act, and that amendment goes into effect September 1st of 2019 to create an exception in the TCPA that it does not apply to those particular types of causes of action. However, it's still a threat to other types of business litigation. Dylan, when must a defendant file a motion to dismiss under the TCPA, and what must he show?
The defendant must bring his motion to dismiss under the TCPA within 60 days of receiving notice of the lawsuit. And in order to succeed on that motion for dismissal, the defendant would need to show that the lawsuit was based on, related to, or in response to his exercise of free speech, right to petition, or right of association.
In order to defeat a motion to dismiss under the TCPA, a plaintiff is going to have to show, by clear and specific evidence, a prima facie case on each element of his claim or cause of action. If his pleading is specific enough and supported by affidavits, this generally is sufficient to defeat these motions. However, these motions are highly complex and generally provide a short period of time for a plaintiff to gather the evidence necessary to defeat them. Therefore, it is important to begin gathering that evidence very early in the preparation for filing the lawsuit if you anticipate such a motion being filed.
And another thing, Joe, under the TCPA, whenever the defendant files that motion for dismissal, that stays discovery, which means that the plaintiff would be relying on his own documents.
Which only increases the importance of gathering those documents early in the lawsuit. Dylan, can you give me an example of when the TCPA might be an appropriate motion to bring?
Sure, Joe. I think a good example would be if you have a customer of a restaurant who doesn't have a very good experience and goes online and writes a review. And because of that experience, the review's relatively negative. If the owner reads that review and then responds by filing suit, that person might consider filing a motion to dismiss under the Tcpa, since it involves their right of free speech.
Thank you, Dylan. And thank you. That concludes this segment of the Vethin Law Firm Video Educational Series. We look forward to you joining us next time.